It's really a pleasure to be part of this event. I was in Paris at the first Ascomacete workshop as a very young student. And now I'm here in a rather different role, I suppose. And my talk, of course, as you've noticed in the title, is quite deviant from other talks. But still, I hope you will be interested in the topic. Because I think, well, I'm absolutely sure that it will affect all daily jobs in collections of whether they are herbaria, fungaria, or culture collections. But I think it will also affect the work all of those people who collect material in the field. And we've heard calls for collecting more material all the time so far. So I hope I will be able to explain some of these things. So the title of my talk is Nagoya Protocol. How do we proceed with fungal systematics? I don't know if how many people have actually read the Nagoya Protocol? Could you raise your hand? Okay, that's not too bad. Good. So, my talk is like this. I start off with explaining the access and benefit sharing, ABS abbreviated, the legal basis and the scope. Then I hope I will be able to provide guidance for lawfully collecting and studying material. What to do when you want to deposit material in a public collection or fungarium, and then some conclusions. So it all started in 1992 actually, with the Convention of Biological Diversity being prepared. It entered into force in 1993, at the end of 1993, and nowadays more than 190 countries have signed and are so-called party to the Convention of Biological Diversity. And the famous main objectives are the conservation of biological diversity, the sustainable use of its components, and the fair and equitable sharing of benefits arising from the utilization of genetic resources. So the key principles behind it is that every state has sovereign rights over the biological resources that are occurring within its territory. Well, this, of course, all started because some countries, well, many countries in fact, were saying we are not getting any benefits from material that's taken out of our countries, studied and used for developing products in biotechnology, etc. But at the same time, the CBD also commits states to endeavor to create conditions to facilitate access, but then on mutually agreed terms and subject to prior informed consent. That's a technical thing that is elaborated in the Nagoya Protocol, and not to impose restrictions that run counter to the objectives of the CBD. This is a very important issue. Okay, there should be fair and equitable benefit sharing, of course. And also, it's about not only about biological material, but it's also about traditional knowledge that is associated with material, and it's often present in local communities. So the Nagoya Protocol took a long time to get there, but it was adopted in the 10th Conference of the Parties in Japan, in Nagoya, in 2010. And last year, on the 12th of October, 2014, it actually entered into force because 50 parties had ratified it at that time. This is really a legally binding instrument, meaning that now all the member states of or the parties in the CBD and that have also signed the Nagoya Protocol have to implement laws in their own country. National legislation has to be implemented. It has to arrange the access. Access is provided to the genetic resources with prior informed consent. That's the requirement. And what is that? Well, it's in fact a collecting permit. So a permit stating what an applicant can collect, when and where. And it should also indicate what then can be done afterwards with the material. And it is issued by a representative organization in the government. Then, connected to that, or as a separate agreement, under civil right most of the time, you have the mutually agreed terms. And these agreements should define the conditions under which the material can be used. So it's important to settle a number of issues. What's the kind of research we want to do? Third-party transfer, is it allowed or not? Deposit in public collection, is it allowed or not? And how do we share benefits if there are benefits? Now, parties of the protocol are not obliged to issue PIC and things like that. So they could say, okay, we provide free access to our genetic resources. Many countries actually do this, especially in the European Union. But the parties are also committed, and this is for each party, to enforce that within their own jurisdiction, genetic resources that originate from one of the other parties are used in a compliant way to the Nagoya Protocol. This is a very important issue. Looking at the Netherlands, we provide free access, and we will ratify the Nagoya Protocol later this year. But for instance, the USA did sign the CBD, but did not ratify it, and therefore it never became a party to the Nagoya Protocol either. Well, in the European Union, there was an early activity by the European Commission to design regulation. This is the way we work in the Union. And it is actually one of the first legislation that was designed, and so it is interesting to see how it will affect other legislations. So the European Union itself is party to CBD, as are the 28 EU member states that we have currently in the Union. The Commission designed this regulation, and it does not interfere with how countries arrange their access, because most will be free anyway, and it is a matter of the member state. But they will interfere at the user compliance level, so they will interfere about that. So as said, most states provide free access, but there are a few where it is clear that access will be regulated or will be under a law. In Croatia, in Spain, probably in France, in Hungary, and perhaps also in Norway. But these countries are still in the process of finalizing their laws. So, the Union regulation applied from the same date as the entry into force of the Nagoya Protocol, because it was already ready by then. And there are three important articles in this regulation, one about user obligations, one about monitoring user compliance, and one about the check of user compliance. And these are applicable from 12 October 2015. This gave the states the opportunity to get their things arranged and the laws in place, but also the user community, say the scientific community and the companies, to adopt to a new situation. Unfortunately, how exactly to adopt is a complex matter. Then there are the implementing acts that arrange some details about what is written in some of these articles, but I will be coming back to that later. So looking at this complex affair, so where are we? Well, we had the Convention of Biological Diversity entering into force in 1993. And then in the course of the time, several countries implemented laws that were based, in fact, on the CBD. They regulated access, or they at least restricted the transfer of material across the borders, which is actually the most important event for most countries to have control over. But then, since 2014, we have the Nagoya Protocol. There are countries that haven't ratified it yet, so they will later on, and that means that it actually enters into force for their territories later. And then we have the EU regulation with these particular articles. And the scope of the regulation really was a test case, because we were wondering about what will actually be, which materials will be affected by this regulation. So the regulation applies to genetic resources, as it is said in the article, over which states exercise sovereign rights and that are accessed after the entry into force of the Nagoya Protocol for the Union. So after this date. And of course also the traditional knowledge. It applies to resources that traditional knowledge to which ABS legislation or regulatory requirements of a party to the Nagoya Protocol are applicable. So only if there is an applicable ABS law, it will apply. A lot of discussion started about the proposal by the European Parliament to have a retrospective effect, meaning that also material that is collected much earlier than the entry into force of the protocol itself, but is obtained by a scientist and used for work, would also fall under this regulation, has been denied. So luckily, no retroactivity, because it would create a lot of problems in practice. And there's probably also no legal basis for this kind of things. However, we witnessed in meetings in the European Parliament, where there were discussions, that some countries outside the EU or their representatives were objecting against this practice because they thought they were not well treated this way. Their sovereign rights were not sufficiently respected. Okay, so an important basic fact of the regulation is that it is based on the due diligence principle, meaning that if you have obtained material, if the authorities ask, you will have to be able to prove that you checked that the material is legal under the Nagoya Protocol. This is very, very basic principle. The scope of the Nagoya Protocol and the EU regulations I want to continue a little bit about. There are, of course, the definitions. From the CBD onwards, there were several definitions. Utilization of genetic resources. What is that? Well, that is to conduct research and development on the genetic resources or the biochemical composition of genetic resources, including through the application of biotechnology. This is from Article 2 in the CBD. A genetic resource the definition is from the Nagoya Protocol, is genetic material of actual or potential value. And the genetic material is any plant material, animal or microbial, or of other origin, containing functional units of heredity. So this would mean that in principle, living or dead material and also DNA extracts would potentially be affected by the Nagoya Protocol and be in scope. Some examples, because it's good to have some examples. Well, biological material within scope is, of course, the genetic resources that are in countries that are party to the Nagoya Protocol. And what does access actually mean? Well, there was no definition of it. Not in the Nagoya Protocol and not in the CBD text. And therefore, the EU regulation put in this definition the acquisition of genetic resources or of traditional knowledge associated with genetic resources in a party to the Nagoya Protocol. There are also things that are outside scope, of course. Human genetic resources, this is a former decision in the CBD. But for instance, microbes that are isolated from human tissues are in principle in scope. Commodities, fruits, food, but also not, in this case, the microbes that are isolated maybe from a mango you've bought on the market, for instance. Plant genetic resources are governed for a long time already by the International Treaty of Plant Genetic Resources for Food and Agriculture, so they're outside scope. And then there's, of course, the material that is not within the jurisdiction of a country at all, the so-called areas beyond national jurisdiction, deep waters, Antarctica. Those are outside the scope of the Nagoya Protocol and also of the regulation. So, research and development. There's been a lot of debate in the European community about what this should actually mean. Well, there was some explanation that the activity has to include an element of development, meaning there are cumulative requirements. So only if you do if you do not develop any product, or there's no primary idea or motivation to commercialize what you are doing, then in principle it would fall outside scope. But it is very problematic, in fact, because we still do not know, and we can mention many examples where it will be difficult to give an answer. Our current understanding, however, is that descriptive research without any element of development is outside the scope. For instance, a morphological analysis would be outside scope. Also, a DNA extraction and sequencing for purely taxonomic work should in principle be out of scope. Another example, if you have a project for drug discovery and you are testing the drugs, then the fungal strains delivering the new compounds are potentially within scope, because if they originate from a country that is a party to the Nagoya Protocol and it's after a certain date collected, then it is in scope. However, if you would use bacterial strains, for instance, for doing the susceptibility testing, so just for seeing if they're susceptible to a certain new drug, then it would in principle be outside scope. This information comes from discussions in meetings that we had with European Commission members present. Not a lot of this is still on paper. So, then a few examples, because what if we have material, for instance, in a collection or in your drawer that was collected in France in 1992? Well, this would be in principle no problem, because it is collected before the CBD, no problem. Then we have material from the USA. Well, in this case, because the USA is not a member, then it's not a problem at all. You can freely use the material. You can freely share it, etc. No problem. A freshwater sample that was taken from Brazil in 2010. Well, it's prior to the Nagoya Protocol, so you would say, no problem. But no, it's not true. There is in fact already a so-called provisionary measure in Brazil active since 2001 that was based on the CBD and that regulates this kind of access. So you should actually have an MTA, for instance, a material transfer agreement, if this material was transferred outside Brazil. Norway, a piece of bark collected on the 16th October 2014. Aha! Norway is a party to the protocol, but there is a problem with Norway now. I don't know if you are aware of the fact if your country has already ratified the Nagoya Protocol and if you actually are a party. Well, I've made a list of countries I know that people are from in this audience, and apologize for people from other countries that are not on the list. But here you can see that from this long list of countries, there's only very few that actually reach the state of the actual being party to the Nagoya Protocol. And these were all on the date that the Nagoya Protocol actually entered into force, as you can see. So, Norway is one of these countries. Well, if you want to look up what the status is of a country, then you can go to this website, of course, of the CBD. You must have seen it before. And there you can look on the Nagoya Protocol under the parties and select Norway. And then you'll see a little bit of information. So since when is it a party? Since when is it, by ratification in this case, a party to the protocol? If you go to the part that says national focal points, then you get people who should be able to help you if you have questions about what the status is of legislation in the country and what you should do if you want to collect there. So this is the national focal point. Sometimes only one person, in the case of Norway, many people. Then if you click on the ABS information, then you go to the so-called ABS clearinghouse. That is a database that is being set up now to keep all kinds of information that is important for us as users of material. Well, you can click on Norway and then you see again there's somebody in charge of the ABS clearinghouse. And here you have space for different types of things. I'll come back to that later. In this case, everything is empty, as you can see. So there's no information whatsoever for Norway at the moment. And because there was no information, and I wanted to know what to do with these samples from Norway, because it's an actual case, I wrote an email. As a public collection, CBS may get offered material for deposit, which was collected in Norway. Norway has ratified the Nagoya Protocol. Do collectors require to have a PIC when collecting, a prior informed consent? And if so, from 12 October of 2014 onwards or already earlier. This information you cannot find on the database at the moment. Well, I fairly quickly got an answer back. Norway is working on the issue of access regulations under the Marine Resources Act and another act. The regulations are not in place, so therefore there are no PIC or benefit sharing obligations for access of genetic resources in Norway. Special rules apply for Spitsbergen. This is a typical situation for most countries at the moment, meaning they have signed the protocol, they may even have ratified, but the point is their legislation is not ready. So there's no information on the websites yet. But in order to be sure that you are correct, if you go there and just collect, I would advise you always to contact the national focal point and check that. This is also a reason why you should maybe do that, because many countries do not have ABS legislation, but as you know, they have requirements for permits for protected areas under environmental laws. So what about collecting then? How should you proceed? This scheme is designed actually for use by CBS or by any Dutch institute, but it is also useful for the EU, but I think it will also be useful for people who work outside Europe, in another country that is party to the Nagoya Protocol, and in some cases also even in other countries that are not a party. Only one country then. So what do? Well, you should check this CBD ABS Clearinghouse website and the national focal point. There's a website, a national website usually also. And consider to involve somebody locally, because that could mean that you get more information, or at least you demonstrate that it is very important that material is, that the project is started in the country, because scientists in the country will also benefit. So you have to find the competent national authority, the access and benefit sharing legislation. If you cannot find anything, you should still ask the question, is prior informed consent required? If you are uncertain because you can't find any information, you should actually ask your local partner in the country where you want to go collect, or the competent national authority. If the answer is clearly no, you don't need this, then you can just start collecting. But beware that it is really important to, in your publications, to, I think, acknowledge the country of origin. Normally you would do that already, it's not a problem, I know. But if there are some kind of permit numbers that are involved, it's also good to mention them. What if it is unclear or the answer is clear, yes, you need a PIC? Well, in that case, you need to work with that competent authority to reach an agreement, to get this permit. And what you will get in the end is, first of all, of course, the prior informed consent, and then also perhaps a separate document, the mutually agreed terms. Sometimes it's called a material transfer agreement, in fact. So it depends a little bit. And these two things, if you obtain those, then you're in the clear and you can go collecting. The idea is that the country will then process this information and wrap it up into a package that has a single unique identifier. This will be the internationally recognized certificate of compliance number. So there will be an international certificate. It will be uploaded on the clearinghouse and it will be public. At least parts of the information there will be public so that people can actually see that it's there. And then if you do your research and if you either want to share the material with others or you want to publish, you have to be sure that you do a number of things in the European Union at least, and this is in the regulation. So you have to keep record of the important metadata, the number of IRCC, the permit, and then you have to keep this information for at least 20 years after the end of use. This is for EU citizens. All this is necessary to prove that you were due diligently acting, if asked, or if you are required to declare something somewhere. And also if you transfer the material, you should be aware that you should actually give it to your collaborators, this information. But as said, these requirements are basically for EU citizens. In the EU regulation there's more, there's also the implementing acts. And one of the things that is interesting about the EU regulation is that there is an article, Article 5, that proposes to start up a register of collections in the Union, meaning that if they fulfill certain criteria, they can be listed on a register, and then users that obtain material from those collections will be considered to have already exercised due diligence, so then the burden of checking everything is actually gone. But these collections, of course, will have to check everything if they accept such material that can be obtained from the collection. There are other instances where declarations have to be made of due diligence. These are formal declarations to a competent authority or to the Commission or to both. And this is when you receive funding for research. Can also be private funding, but also public funding. And in the case you want to bring a product to the EU market. Well, I cannot go into the details of that. And then there's also the best practices that I will talk a little bit about later, and this is also regulated in this text. So, well, if you're not going to use the genetic resources in the sense of the Nagoya Protocol or the EU regulation during my research, should I bother at all? Well, beware that taking biological material from a party without PIC, where it is actually required, is strictly prohibited. And that persons that are apprehended at the border, for instance, could face high fines or imprisonment. And also, of course, your reputation could be at stake. So, and if you need to deposit the material, for instance, in a fungarium or a culture collection, the collection will ask you, is this material legally collected? Did you have a permit or not? This is really necessary for them, because if they're in the EU or in a Nagoya Protocol party, they will actually have to have that. And if they want to transfer the material later or use it for their own research, then they also need that information. And if you obtain material from your collaborating friends, it could happen that they are not aware of the fact that there already are documents linked to this material, and that it says some things cannot be done, for instance, and that you are not aware of this. And this can also end up to be a real problem for you. Yeah. So, the procedure for deposit in public collections, it is obvious that a minimal amount of information is necessary for the curators to assess, is there any possible problem with the Nagoya Protocol? So, we need to know, of course, the geographic origin. We need to know the date of collection, and we need to know exactly who collected it, and actually also who is the legal entity that is represented by this person, because when there would be legal issues. And then, if such is required and available, the RSCC number and all the other stuff. Beware of the fact that in the case of your country, the national ABS law may actually require more things. But this is actually basic stuff that is in the list. This is our accession form. You can now enter some more information than before that is linked to the Nagoya Protocol. So, if you want to deposit in closed collections, that is more easy because most of these things do not fall under the Nagoya Protocol, including the Budapest Treaty patent deposits and also safe deposits that are the practice in some culture collections. So quickly wrapping up now. So, to resume, before collecting, at the moment that you either accept the material of somebody else, you have to make sure that you check a number of things. This is the best time to do it. Also, the institutes that we work are actually vulnerable if we publish a lot of information, because we can expose ourselves, and it's already happening that people in some countries get the assignment to check publications, to see what's there, is it legal or not. And important, I think, is to note that initiatives from institutes in developed countries to work together with local partners can help actually a lot. To build biodiversity research capacity, of course, there. To have a local partner that maybe is better or taken seriously more with the authorities in his country. and for the foreign partners itself to have a chance of getting access at all, because there are some countries that are quite restrictive already. It's good to settle the terms of benefit sharing in an early stage if you can, and to also make sure that it is possible to deposit, for instance, because this is often important for you when you publish, and of course for a collection like CBS it's obvious. So emphasis should be placed on non-monetary benefits if you can, because many countries still think about the money most of the time because they think they can get the benefits. Well, it's good that they get them if they are there, but the non-monetary benefits are actually, in practice, probably delivering much more for them. It is a good idea to think about implementing an ABS policy in your institute, so that everybody knows what is being expected of them. And in the culture collection community in Europe, we are busy in a new network which is called the Microbial Resources Research Infrastructure, and there we are talking with the EC and with other stakeholders and trying to develop best practices that we can implement to make our lives easier and to also make it better. And I think, to conclude, international harmonization of ABS regimes is actually very much needed. The EU has started with this, and I think that, and I hope that some integration will be possible. Thank you.